Hi everyone, Sharifa here from ST Law Office. I am U.S. Immigration Attorney. I work at ST Law Office and I am here to take your immigration questions. So go ahead and put your questions in the comments and I will be glad to answer your questions. So I usually come with a topic of my own today. And today I'm going to talk about applying for citizenship. Now, there was the news that the Biden administration has decided to reverse Trump's change to the citizenship test. As of March 1st, the citizenship test will revert to what it was before. So if you recall, Trump had implemented a new test that included 128 possible questions that you had to study for. Now, when you're studying for this, it's based, you have to remember the answers. It's not multiple choice. So, Trump had increased it from 100 to 128 possible questions. And then in addition to that, he increased the number of questions you had to get right to pass the test. So previously in the old test, it was you had to just get 6 out of 10 right. And so if you answered 6 back to back to back and they were all correct, your test would be over and you would pass. Now the new test, they increased it to 12 right out of 20 possible questions. So that can be, make it difficult for some people to be able to pass that test. And so after March 1st, it will revert back to what the original test was to make it a fair and more accessible citizenship process. So given this news, I thought it would be quite fitting to talk about applying for citizenship from top to bottom and the entire process. So as you know, I'm a U.S. immigration attorney. I help individuals to get the green card and in the process get their work permit. But that also means sometimes taking them on the journey to citizenship. So I do help people to apply for citizenship as well, especially where citizenship can get a lot more complex. Hi there, One User 6. Hi, Chocolate 3185. Thank you for joining in. Hi, Vince Yam. It's nice to see you. So let's talk about the citizenship. So who qualifies for citizenship? So if you have had your green card for 5 years, or if you got your green card, hi there, Umoshin. It's nice to see you. And thanks for joining in. Now, hi, Charming Rose. Hi, Ariana. It's nice to see you. Cuban Dollberry. It's nice to see you. Thank you for tuning in. So, in order, and I want to stop for a minute to just let you know that you feel free and welcome to drop your questions in the comments because that's why I'm here mainly. But while the question, yes, please go ahead. That's exactly what I'm here for, Umoshin, is to answer questions. So you go ahead and send your question and I will definitely answer. So while that question is coming in, I want to talk about citizenship, right? But as a reminder, please go ahead and drop your questions and I will answer. It doesn't have to be related to the topic I'm talking about. It could be anything that's immigration related. So, Umushin, my cousin was here 10 years or so ago. Okay, so I'm waiting for the rest of it. So while I wait for the rest of it, I'm just going to go back to who qualifies for citizenship. Hi, Shay was here. Hi, Tashu. Hi, Munat Jume and Miriam. It's nice to see you. Thanks for joining in. So who qualifies for citizenship? If you have had your green card for 5 years, or 3 years if you married a U.S. citizen and got your green card through that U.S. citizen, then you can apply for, that's the first step in determining whether you qualify for U.S. citizenship, right? And I want to note that, so Umushin, my cousin was here 10 years ago or so. She came here by her dad. He filed for her, but she was sent back. Okay, so so if I'm gonna wait, it seems like there's still some more left. But she was sent back to Africa 2 years later. She doesn't have a green card. Okay, and can you tell me who sent her back? Was it the immigration service that sent her back, or was she deported, or was it her dad that sent her back? Okay, the dad passed away. And okay, and who sent her? Was it the relatives that sent her back? Because there is something called humanitarian reinstatement, but her situation is a little more complex because she's outside of the country, and I don't know how long ago this was. But it would definitely, in order to see what option she has, humanitarian reinstatement, it allows someone else to step in and take over the paperwork and sponsor her. Okay, so the dad sent her back and then died a few years later. So there are a number of options that are coming to mind here. So the first is, what happened between her dad and herself? Why did he send her back? And did that involve some sort of mistreatment by her father? So that is my first question, because there may be an option there, but it once again, it just depends on the facts. So there's no real simple answer to this question. And if he sent her back, were the papers still processing at the time that he passed away? So if the papers were still pending when he passed away, then there's also the humanitarian reinstatement. But since he sent her back and she's now outside of the country, it also depends on the facts. So what you can do is, if your cousin is interested in returning, you could schedule a consultation, or she could schedule a consultation with me to get a little more in depth, because that is a little more complex, and there is no straightforward answer to that question. So I'm going to put my number under so it's under the immigration attorney. You can write that number down. It's in the comments. It's 561-405-4889. And, you can schedule a consultation. My consultation fee is $150 for up to an hour. But I always like to say it is worth it, because you walk away knowing your options. And with you also have the option of getting further representation if that is necessary. So it is worth pursuing that, even if there is a fee, because you walk away with some value, with knowledge, and you're fully informed. So what you can do is give me a call, and the firm's receptionist will get you on my schedule. Thank you, Chocolate3185, for sharing my live. I really appreciate that. Philip, I got a 1-entry visa. I honored my visa. Will I be able to get a multiple entry visa? So you will need to, I guess, apply for that. I don't know the circumstances of the 1-entry visa. You're welcome, Umushin. Now, it's great that you complied with all the terms of your visa. And so there's no guarantee you'll get the multiple entry visa. because that visa, which I think you're talking about, the B2 visa, which is the visa for visitors to come into the United States, is really dependent on whether you have strong ties to your home country. That means that they're convinced based on the evidence at the interview that you will return to your country after your visit. It definitely looks good that you complied with your one entry visa, but you have to make sure that when you're reapplying to get the multi-entry or hoping for a multi-entry, that you can also present good evidence showing that you have strong ties to your country and you will return. Hi, Miriam. Hello, I will be 5 years in August. Can I apply for my citizenship in May? Yes, you can. Now, that's assuming, of course, that you qualify in other ways. So, yes, if you will have your green card for 5 years in August. Here's the great part about applying for citizenship is that you can apply at 4 years and 9 months. So 3 months before your 5-year anniversary. And same with the 3-year, you can apply at the 2-year and 9-month mark. So yes, you just want to make sure that you qualify in other ways, that you meet the continuous presence requirement, the physical presence requirement, the good moral character requirement, and you've been living in your state of residence for at least 3 months, then you will likely be good to go. Now, there are some things that you have to watch out for with the citizenship. So where you need to be extra careful is if you've been outside of the country for more than 6 months in the past 5 years, if you have any kind of criminal issues pending or in the past, tax issues, child support issues, these are issues that you want to make sure that you get legal advice on or you get guidance and you're prepared for what may come if you have any of these issues. So, hi, Heavenly Ice Angel. Is having a baby enough proof for someone who needs forgiveness? So, not necessarily, Tashu. It depends. So, it depends on your baby's status. It depends on who will be taking care of your baby. It depends on whether there are other hardships. So I'm assuming you're talking about an extreme hardship waiver. And it definitely would help to show, for example, if it's your spouse that you're trying to prove they'll experience extreme hardship, then usually as a parent, you cannot show the extreme hardships of your child. But what you can do is show how having a baby will have extreme hardships on your spouse, on your U.S. citizen or legal permanent resident spouse, or if you have a parent, you can show hardships on that parent as well. So for example, if you are the immigrant and your baby has to stay in the United States, and stay with your spouse will be the main caretaker. They will have to raise your baby alone. You take care of child care responsibilities and expenses. This can amount to extreme hardship for the spouse. So that's an example of how a baby can be evidence of the extreme hardship and then lead to you getting forgiveness. But by having a baby alone may not be enough. It just depends on the facts. If you would like assistance with your waiver, if that is what you're doing, give me a call at 561-405-4889. I can definitely help you with that. My green card is 10 years. So Miriam, yes, you can apply at 5 years. Even though you have a 10-year green card, you can apply at 4 years and 9 months. Shay was here. Did any of Biden reforms reduce the wait time for green cards or citizenship. It's supposed to, yes. So it is designed to reduce the wait time. Yes, so it is meant, it is designed to reduce the backlog for green cards. So we will see what happens and what is taken out, what's put in, and whether that all passes. Philippe, I work with the government in my country. My mom lives in the States, but she's sick. I'm sorry about that. In the case that your mom is sick, that may play into a decision to allow you, and may have played in the decision to allow you to see your mom in the past with a single entry. But the job in your country working with the government can definitely show strong ties. I'm sorry about your mom though. So these questions are delayed, so please forgive me if I take a while to get to your questions. Let's see. User Samira, how do I apply for my mom? So if you are a U.S. citizen, you can apply for your parent. You're welcome, Teshu. You can apply for your parent. So you have to, now if you are a green card holder, unfortunately, green card holders cannot file for their parents. So you'd have to first become a U.S. citizen, and you have to be 21 and over to be able to sponsor your mom as a U.S. citizen. But that would be basically, if your mom came into the country and she overstayed her visa, then she would still qualify for the green card in the United States. However, if your mom came and she, came in without a visa or without legal papers, then she's going to require a waiver. But you can apply for her. It doesn't completely disqualify her. It just changes the way the process is going to go. She'll have to leave the country, but first apply for a waiver to leave the country to be able to apply at the embassy. But if you are a U.S. citizen and your mom just overstayed her visa and she's here in the United States and you are 21 and over, then she can qualify to apply for the green card in the United States. So thank you, Shay was here, for sharing my live. Hi, Queen Anna Diva. It's nice to see you. So Philippe, so I'd like to visit her at least twice a year. So yes, I understand that. And in order to visit her, you will definitely have to apply for that, for the visa. And you could state to the officer the reason, that your mom is sick and you would like to have the opportunity, the flexibility to visit her as often as you can. But that is never guaranteed. Unfortunately, even with your mom being sick. Did any of Biden immigration rules apply as yet? No, none of it has passed yet, and it is going to be quite a process. We're thinking it could take months to maybe even a year or more. So just hang tight. We have to be patient. I'll keep you updated as I watch for new developments. Miriam, you're welcome. Great questions. Keep the questions coming. I'm talking about applying for U.S. citizenship and who may qualify. So, I speaking of, so Mariam, we spoke about qualifying, how long you had to have the green card and what you need. So you need the good moral character, okay, so let's see. I have more questions here. So user Samira, you are a U.S. citizen. That is great. So you will be able to apply for your mom. And if she came into the United States with a visa or with permission, then she would qualify. She has been in the USA, but she didn't get a green card and she went back home and didn't come back. Okay, so in the case that, now with that, I wonder, I need to know more facts. If your mom came to the US and she overstayed and she was in the country undocumented for more than 6 months, then she would be barred for 3 years from re-entering the United States. Or if she overstayed her visa and stayed undocumented in the United States for over 1 year, then she could be barred for 10 years. So it's very important for me to know that, because if that bar exists, she'll have to apply for a waiver, it's called an unlawful presence waiver. So if you're going to apply for your mom and that bar still applies, then she will need to apply for a waiver. But it all depends on the facts, when she came, when she left, in order to provide you more information. She's been home for 12 years now. Okay. So even if that 10-year bar applied, it may be past the 10 years. But if you would like to definitely go ahead and sponsor your mom and you need help, give me a call so we can go over all the facts of what happened and to determine how your mom qualifies and how to approach it, because it may be a little more complicated. You can give my office a call at 561-405-4889, and you will speak to the firm's receptionist, who will get you on my schedule, and then we can evaluate further. Yes, so definitely give me a call. I'm going to go ahead and put my number in again. So that's 561-405-4889. And it's in the comments under the immigration attorney. You can write that down and then give me a call. So, Feli, thank you so much. Thank you for your compliment, and I will definitely keep it up. I really appreciate you all coming and engaging with me and allowing me to answer your questions. So, thank you as well. User, I will do that. I am looking forward to hearing from you, and no problem. Crystal Douglas, my husband is filing for me and my kids. You think we're all going to travel together? So it depends on the type of application. So if your husband is a U.S. citizen and he is filing for you, then he filed separate petitions for your kids. They may not all be processed at the same exact time, and that may affect who can travel together. So it depends. Sometimes, you could put a request in to try to have them all processed together so that it reduces the risk of your kids and yourself being separated for a short period of time, hopefully a short period of time. But if not, that's never guaranteed. So you can put the request in, but it's never guaranteed that it will go that way. If your husband is a green card holder and your children are included on your application, then you will be able to travel together. But if you have separate applications that your husband filed for each person because he's a U.S. citizen, then there may be different processing times, different interview dates. So it just all depends. Thank you. I believe that's Mark Malang. Thank you for sharing. Thank you for following me. Thanks so much. So Crystal, so he did. So if he filed separate petitions, then you could possibly face that prospect of maybe you get the interview and then another child gets the interview, another date, and so forth. But hopefully they would be close together, and there's always the possibility to submit a request to get to process them all at the same time under the circumstances. So user 199, what are the qualifications to petition for a child? So if you are a U.S. citizen, you can petition for your child who's under 21 and unmarried. If you are a green card holder, you can petition for your child who's under 21 and unmarried. Right now, if you're a citizen, that child will not have to wait for what's called an immigrant visa number. That's what usually takes a long time, is to wait your turn to get the immigrant visa number. U.S. citizens who are sponsoring their child who's unmarried and under 21, they don't have to go through that. So they take priority, and the process, I can safely say, takes about 2 years. It could be less, maybe even more, but 2 years is a safe bet for the process at this time. That could always change. Right, so that is basically who would qualify under a U.S. citizen. Now, I want to let you know this. If you're a green card holder, you want to sponsor your child, now is a good time to do it, because there is no wait list for that immigrant visa number. But keep in mind that could always change, because it's always changing. The more people that apply is the more the more slots that are filled up, the more people that the immigrant visa numbers are going to. And then eventually there are going to be more applicants than there are immigrant visa numbers. And then there's going to be a wait list again. So if you are going to apply for your child as a green card holder, do it now, because your child can go straight through the process without worrying about waiting for that number. If you do become a U.S. citizen while the process is pending, then you can upgrade your child to this relative of a U.S. citizen, and that will keep them as priority through the green card process. So you also have that option as well. Miriam, but up till now, no approve yet for my husband and my 15-year-old daughter. So it depends. So if you're a green card holder and you, I don't know when you applied, but it all depends on your priority date. So it depends on that date that you applied, and you would have to refer to that to see if they are currently processing it. That's the way to gauge how much time you have. So if you go to the National Visa Bulletin, and you look at if you're a green card holder sponsoring your husband and your daughter, you're going to look at your category. And when you look at the category that says, permanent resident who's sponsoring their spouse and child under 21, you will see dates. And that date, the date that's there, is the date that they're currently processing. Anything before that date has already been processed or is in process. So if your date falls after the date that you see, that means that they still have yet to get to your date. So go ahead, and if you need assistance or if you'd like to figure out what's going on, give me a call and we can talk more about it. Shay was here. If I'm petitioning for 2 people, should I have twice the funds needed to petition for one? So there's the household poverty line guidelines. And if you go to the uscis.gov website, you can pull up poverty guidelines. And you will see the income. So if it's you, your spouse, and your child, or the 2 people you're sponsoring, that's going to be, if you have to count the household size, the household. So who is in your house now, and who will, and including the immigrants that you'll be sponsoring. Then you're going to look to see how much you can make. But it doesn't necessarily mean twice it doesn't mean twice the money. But what you're going to have to do is look at your household size. So Miriam, I filed for my husband and daughter last year, but US sent me a letter already last year. Okay, so it's taking about 2 years right now for the process to go through. Now, where you have to wait is for the approval of that I-130. And then once that's approved, then they should start going through the process. And then remember, last year they had put a pause on the immigration of everybody except for U.S. citizens and their relatives. So that may be a part of the delay as well. So Kimona 320, I'm a green card holder, wait to file for my mom. So you're a Kimona, I'm a green card holder and I want to file for your daughter. So yes, you can file for your daughter, and I'm saying now is a good time to do it because there's no wait list right now. Keep in mind that could always change. But right now is a good time to do it. And even if when you become a citizen, you can upgrade your daughter to the relative of a U.S. citizen and she'll continue to have priority in the process. Miriam, I applied last June. So yes, so it is still taking a while. And I like to say prepare for a 2-year process. So it takes about 6 to 12 months for that I-130 petition. That's the initial application you file to be approved. And then after that, it goes to the NVC and then the embassy. So hang tight. And if you need assistance, give me a call. Feli Am, does a 10-year green card holder have to wait for citizenship to petition for my mother? Yes, you definitely have to wait. Unfortunately, green card holders in general cannot file for their parents. User 199, can a green card holder petition for their child in Jamaica? Absolutely, yes, you can. And now is the time to do it. Can you file for your child when you are filing for your green card? So it depends on how you qualify for the green card. Now, if your spouse is filing for you, a U.S. citizen spouse is filing for you, then that U.S. citizen spouse will have to file for your child if they are under 21 and unmarried, and if you got married. So if your spouse is U.S. citizen spouse is a step parent, you would have to show that you got married before the child turned 18. But that is one way that your child could go along with you if a U.S. citizen is sponsoring you. If a green card holder, your green card holder spouse is applying for you, then you can include your child on the application. If a green card holder parent is sponsoring you, then you can include your child on the application. So in any other category, you will be able to include your child as long as they're under 21 and unmarried. So Crystal Douglas, what about the 4-year-old? I may have missed something here. Let's see. Okay, so my husband is filing for me and my kids. You think we're going to... So what about the 4-year-old? So with the 4-year-old, if your husband is a U.S. citizen and he filed a petition separately, you will have to definitely let them know that you have a 4-year-old that you can't leave behind, and you'd have to put the request in that they process the applications together so that you avoid family separation. But that's never guaranteed. So yes, unfortunately. So one user 6, thank you for sharing my live. Chanel Rose 81, thanks for sharing my live. Crystal Douglas, you're welcome. And Miriam, you're a green card holder. Yes, so you are a green card holder. But right now, you applied last year for them, but there is current, so the process should be moving along. It's just that you have to wait initially for the I-130 petition to be approved, and then it should move forward from there. So Shay was here. Do you operate in all states? Yes, I do. I represent clients all across the country and the world. When we represent our clients, we work with USCIS offices all across the country. So we are experienced. I'm experienced as an immigration attorney with representing clients across state lines. My office is in Florida, Boca Raton, Florida. I also meet my clients in person in downtown Fort Lauderdale. But for those of you who are in other states, I can represent you and I can help you. You're welcome, Feliam. Dark Horse 45, it's nice to see you. I called the number you gave us, but it never rings. So I don't know which number. Now, if you're calling 561-405-4889, it should be working, and we are receiving calls on that number. Now, I know about a week ago, my phone number was down. So I gave you another number, which was 561-286-7650. That one should be working, but I'm going to put in the number that is up and running again. And then I will look into whether that other number is still working. But in the meantime, call this number. 561-405-4889. Dark Horse 45, my number was down, so that may have been the issue. But try again and you should be able to get us now. Tracy 30, you have to wait until you get the green card to file for your daughter. So it all depends. If you have a US citizen spouse, and your daughter is under 21, and your daughter was under 18 at the time you got married to that US citizen spouse, your US citizen spouse can file the papers for your daughter. That way you don't have to wait until you get the green card. However, if it's any other way, like a US citizen parent is filing for you, or a green card holder, if a US citizen parent is filing for you, then you will have to wait until you get the green card. However, if a green card holder parent is filing for you, or a green card holder spouse is filing for you, you should be able to include your daughter on the application as long as that daughter is under 21 and unmarried. Umoshin, can a green card holder file for a relative? So green card holders can only file for their spouse, their child under 21 and unmarried, and their unmarried son or daughter who's over 21. And also their kids can come along, but the green card holder cannot sponsor married children. Great questions. The Cruz Familia, thank you it's nice to see you here, and thank you for sharing my live. Kumona 320, thank you for following me. Keep the questions coming, because that's what I'm here to do. I am here to answer your immigration questions. I always like to close the night out with you all and, answer those questions, because I know if you're thinking about going through the process or you are going through the process, you have those nagging immigration questions. So go ahead and... Hi, there's SKD2286. It's nice to see you here again. So UNET, if someone come to the country 2 times, the April 1st, 1997 applies. So if they came twice and, if they came and without permission, so if they came, they were sent back, then they came again, yes, that would apply, unfortunately. Tracy, you're welcome. Unette, you're welcome. And SKD, you're welcome. Finn's Mammy, do you represent women of domestic violence who are made reliant upon their partner? So yes, I do represent immigrant women as well as men. So whoever has been the victim of domestic violence and they are here without their papers, or even if they're here with their papers and they're here with their papers, but the spouse, you know, is subjecting them to domestic violence, not applying for them, or even applying for them, but they're in the middle, they're being abused, I can definitely represent them. If you know somebody, or if you're going through this, just give me a call at 561-405-4889 and we can talk about it. If it's immigration related. UNET, they never got detained. Even if they never got detained, if they left and came back, then that is going to still lead to that bar from, you know, getting a green card. So Sendes, my husband is a citizen and I'm a permanent resident. Can we file for a child that we have guardianship of? So you will need to adopt the child. They wouldn't qualify based on just guardianship alone. You would have to adopt, and that would have to be before the age of 16, and it would have to meet the requirements of legal adoption in the United States. However, there are other ways. So you said that you've been given guardianship. So there is another way, and that is if that child is under 21 and you have guardianship because the parent has abandoned them or has left them, then there is a way for them to obtain the green card through it's like a special juvenile status. It's a little more complicated, but what's required is that is to prove that they are basically have been abandoned, and you know they can go through the green and get the green card that way. What you can do is give me a call at 561-405-4889, and we can talk a little more about the circumstances that's involved. And I can provide you, let you know whether that child would qualify for this process. Okay, now I file for my husband and daughter when I'm a green card holder. So I think that is, that has been cut. Unette, you're welcome. So send this. You have guardianship, but you will definitely need to adopt and actually become the parents. Otherwise, you can set up a consultation with me to see if your child that's your guardian of can qualify for this special juvenile process where they can obtain the green card as a child that has been left behind or abandoned by their biological parent. So I'm looking forward to hearing from you. Definitely sounds like that's a case for that. So I just want to confirm with you. Urena, it's nice to see you. So the U visa, let me just make sure I didn't miss anything. There's nothing new with the U visa. No new news. The same. It is the same. The law that would increase the number of U visas is currently pending before Congress, but no movement yet. And if you want to follow up on that, just let me know and I can get a little more specific. Thing 70. What about for those seafarers that came in the U.S. and marrying a green card? So yes, so in the case, so I believe what you're talking about are crew members. So in the case that a crew member marries in the United States, there are some exceptions to them. So if they come overstay, so they get the crew member status, meaning they get to come into the country because they're crew members of either a ship or a plane, but they overstay and then they get married. In some cases, they would not qualify for the adjustment of status process. So with that, you would definitely want to consult. What you can do is give me a call at 561-405-4889 and we can talk about your options. Feli Am, thank you for sharing my live. I appreciate that. Could you explain humanitarian parole? For Shay was here. So humanitarian parole is a way for individuals to apply to come into the United States for a temporary period of time for basically humanitarian reasons. So it could be if a relative is sick here, it could be for an emergency and a reason that's an emergency in the United States. It could be based on, the fact that maybe the person is facing, say there's family separation and they allow a relative from outside of the United States to come and stay with a relative and then continue the process here. So it's basically a type of benefit, immigration relief that you file for if you don't have a visa to come into the United States, but you need to come into the United States for a reason. And it just depends on the circumstances and the circumstances. There is no specific qualifying criteria because every case is different. So the officer is going to make a decision based on each case and the circumstances in each case. But it's basically a way to apply to come into the United States if you have no other way to come in and you have a good reason to come in. So Irina, yes, it seems I missed your first part of the question. So can you retype it? Because I somehow that did not come across. So go ahead and retype that question, Irina. So keep the questions coming, please. I really enjoy answering them. In the meantime, while questions come in, I just want to let you know who I am. I am immigration attorney Sharifa Tharpe. I help clients to get their green cards or get their work permits through different forms of immigration benefits and relief. And so you can go to the link in my bio and that will take you to the website where you can learn more about me, my practice areas, what I have done, the type of cases I do, and you can communicate with the office by phone, also through the online chat feature. So these are, all the ways that you can get in touch with me. So Urena, so if your spouse got denied through parents filing, can you file for him while you file for your U visa? Yes, you can. So while you are applying for the U visa, you can include your spouse on that application as well. So SKD2286, I am on H-1B visa and we file brother, sister file on 2009. Can we do adjustment of status? So if you are, yes, so if you have the, if it is current, once it becomes current and you can maintain your legal status for the duration of the process, then you can do the adjustment of status. So that is one way. It's not very common, but if you can maintain that H-1B status, you can do the adjustment of status process and apply for the green card in the United States. What if the seafarer from ship came? Can they get a green card from marrying U.S. citizen or green card? So it doesn't disqualify them from getting the green card. However, they would not qualify for the adjustment of status. So in that case, you want to make sure that your circumstances don't fit within that. And so what you can do is give me a call and schedule a consultation, and then we can talk more about that. So are we back to 100 naturalization questions? And said, yes, Dark Horse, we are. We are back to, so as of March 1st, it will go back to the 100 questions. So that is great news, right? So let's see. So Miriam, let's see. If someone filed for his husband and daughter as a green card holder, can I now file for citizenship in May? So Miriam, if you file for your, yes, and you get your citizenship, you can still apply for your citizenship, and when you get it, you can upgrade your spouse and your daughter to now immediate relatives of U.S. citizens. But one thing I have to state is if you didn't file a separate application for your daughter, you will need to file a separate application for your daughter because it's a funky part of the law. But if you are a U.S. citizen and you sponsor a relative, that relative cannot have a child or a dependent come along with them. That's only allowed in other categories. So you're gonna then have to file a separate application for your daughter, which can be a pain because now your daughter's application is going to be pending for longer than your husband's. If you want to upgrade your husband to now the spouse of a U.S. citizen. But you can upgrade, it's just that there's that quirky part of the law. And as I said before, give me a call because this can get complicated and you want to make sure you're doing everything correctly. So if you want to be sure that you are okay in the process, give me a call at 561-405-4889 and we can talk a little more about what's happening. Shay was here. Is it normal for the 10-year green card to take over 6 months to approve or just to get a response? Unfortunately, yes, right now everything is taking long, everything is backlogged. I know before COVID, it would take up to 9 months to get the green card renewed. It's not anything new. What you can do is try to contact them to see what your status is, to see what the holdup is. But unfortunately, across the board, we're seeing longer processing times, and hopefully that's something that Biden will address. So let me go back, make sure I didn't miss anybody's questions. So Urena, definitely, I just want to repeat that spouses and children, if necessary, can be included on the U visa application as well. The U and the T visa application. So that is one of the benefits of that type of visa. So keep the questions coming. I was talking about applying for US citizenship and okay, so we have more questions. So let me go through them. So SKD 2286, I filled the I-765 on October 29. When should I get approval? So it all depends on whether you qualify, right? But as long as you qualify, it's taking about 6 to 8 months to get these approved. Maybe less, maybe more, but it's a safe bet to say prepare for a 6-month process. Gabans, can you still apply for the green card even if you are not married to a U.S.? Now, it depends on what you qualify for. That's a very broad question because you could qualify through other family members, like a parent, a U.S. citizen, or a legal permanent resident parent. Or if you have an employer who is willing to sponsor you, that may be a way. So it all depends on what you qualify for. Denny K, 24. Let's see. If you got married while visiting on a visa, is it best to go back to your country and do paperwork? You know, it depends. Now, if you got married to a green card holder, and then you're going to have to apply for a waiver, and that can get a little more complicated, and the waiver is never guaranteed. In that case, I would recommend going back and waiting the 2 years for that process to go through, so that you can avoid applying for an unlawful presence waiver, which is never guaranteed to be approved. And once you stay for over 6 months, then you will have no choice but to apply for that waiver. You can't leave the country. So here's the tough part. If you're married to a green card holder and you overstay your visa, and you overstay for over 6 months, if you leave the country from that point on, you're barred for 3 years. If you wait for over a year, it's 10 years. So it gets to the point where you're at a point of no return. But at the same time, you will not qualify for adjustment of status, unless, of course, you're in a situation where, say, the spouse that you married ended up mistreating you or being abusive. Then you could apply on your own based on that mistreatment. But that's a whole nother different story. If you are in a marriage, you're doing well in your marriage, and you overstay your visa, you're going to be barred if you leave. So you'll have to apply for that unlawful presence waiver to be allowed to leave the country to finish the green card process at the embassy. So it gets a little more complicated. If you're married to a U.S. citizen and you overstayed your visa, then you will still qualify. I mean, all being well, and there's nothing that disqualifies you, then you will qualify to apply in the United States despite the overstay. But, there are other personal things that you have to think about. So, for example, you will not be able to work, or you may have to work under the table, which is not legal, but, people have to survive. And if they do that, it leads to a period of frustration. If you are here, you can't work. If you're fine with that, you and your spouse are prepared for you to stay and not work, or to, work but not make enough money for yourself, or not make as much as you want, then you can make the decision to stay. It really comes down to what's right for you and your spouse. Dark Horse 45. Yes, I know, right? It's pretty awesome that so Denny K 24, you missed my question, so let me go back and see. So I think if you got married, so I think that was it, and I just answered it. So I think I got to it now. When applying for citizenship, will USCIS count the time it took to get the 10-year? No. So they don't count before you became a green card holder. Now, what they do count, they will count. If you got the 2-year green card, they'll count those 2 years. Then when you get the 10-year green card, they'll count those years. So yes, that is counted. But anything before that, if you were not a green card holder at all, that doesn't count. Miriam, when I file for my citizenship in May this year, how long will it take for USCIS to call for me for the exam? So right now, I have clients that are going up 6 months. In 6 months, they're getting getting that interview. But it's just because my clients get the 6 months doesn't mean that that's guaranteed for you. It really all depends on the location of the office, what the processing burden is in each office, because remember, the office that's going to administer the exam and the interview, they are in local areas. So there's a USCIS office that's closest to you based on your area. And it may depend on how many cases they have to do. But I am seeing as little as 6 months. So it could be as little as that if you're lucky. But it all depends. It's taking from anywhere from 6 months to 1 year for the green card process to be complete. So Thane 70, I petitioned my daughter and she got here before 18. Do you think she'll qualify to be a citizen? So if she's under 18, when you become since I was a US citizen and I petitioned my daughter, she got here before 18. So yes, so it depends, it really depends on the circumstances involved, but she should be able to qualify through you for US citizenship. What you can do is give me a call and let's go through the details, because when you become a US citizen, and your daughter will become a US citizen as well once she becomes a permanent resident and she's under 18. So I would just want to confirm that, just have a conversation with you in a consultation to make sure that everything is lined up for that to happen. You can give me a call at 561-405-4889 and we can talk a little more. Peter James 2020. So my wife has a 10-year green card and I'm currently on an F1 visa. Do I have a chance at adjustment of status? So if you can maintain your legal status for the duration of the time, then you can do the adjustment of status. So yes, but it all depends on whether you can maintain that F1 status for the duration of the process, which right now is taking about 2 years. So I filled my I-765 before my asylum and got denied. I sent the asylum and done my biometric. You're welcome, Denny K. So let me see. Nura, I noticed that. So, Nora, I noticed that the question is incomplete, but I think I know what you're getting at. So I don't know the particular circumstances in your particular case and how long ago you applied for asylum or what it is. But generally, if you applied for it before you applied for asylum, then yes, that would be denied because you wouldn't qualify for the work permit. But if you have now applied for asylum, then you can definitely apply for the work permit, but you want to make sure that you meet all the requirements still. So just give me a call and let's talk more about your situation. But once you are, usually when you have a pending asylum application, you can apply for the work permit. Chrissy Boo Babe, thank you for following me. I really appreciate that. Asha Smith, it's nice to see you. How do you get a permit? It depends on what you qualify for. So usually to get a work permit, you have to qualify for a type of immigration benefit. You have to be applying for a green card. You have to be applying for some sort of visa. So it's not something that you can apply for by itself. You have to be going through some sort of process to get a green card or get a type of visa to get the work permit. Okay, so Denny K24, do you have an idea how long it takes to get your work permit after filing the paperwork? Okay, so I think, was it Denny K? I think we, let's see. Okay. So Denike, it's taking, I can safely say it's taking about 6 to 8 months. Could be less, maybe more, hopefully not. But the average time I'm seeing right now is 6 to 8 months for the work permit. So my work permit, one of my work permits just came through in 4 months. So the tide may be changing, but I like to prepare my clients for a realistic time period, and it's 6 to 8 months. So I'm just looking through to make sure I get everybody's questions. And Lil Star Rush, I think I don't see the rest of your question. So can you retype your question again so I can see the full thing? So do you have an idea how long it takes to get work? Okay, so I answered that. Chrissy Boo Babe, if my husband don't have his taxes for 3 years, can he still petition for me? He can. Yes, he can. However, it all comes down to the he will have to prove his income on the affidavit of support or get a sponsor to step in. And in addition to that, he will need to attach an explanation as to why he has not had taxes for the past 3 years. So the U visa work permit time frame, I would say right now, because they have to initially review the application and put you in a type of deferred status, it's taking about 6 to 12 months just for that to happen. So it takes a while, but if the U visa is the only option, as it is for many people, even that 6 to 12 months pales in comparison to the time that they've spent in the United States without anything at all. So unfortunately, it does take up to 12 months for that to be reviewed and to get into the deferred status. But after that, there is a work permit that can be approved. Asha Smith, you're welcome. Thane 70. Thane 70. But she's 33 years old. Do you think I can still file under me to become? So if you were not if she came into the country and she was under 18 and you were a U.S. citizen, then she could have derived citizenship from you. But I would want to evaluate your situation in a consultation to make sure that it's that she in fact qualifies. If you obtained U.S. citizenship after she became 18, then she wouldn't qualify to get it through you. So it all depends on the facts in your circumstances. User 543. The decision of I-130 was suspended last time. Did they start the process? So yes, so at this time, I believe Biden has lifted the restrictions that were in place on green card holder, because it wasn't all I-130s, but it was on basically green card holders and their relatives. And I believe he has lifted those restrictions. Hi, do you know your... Yes, Sania. I'm not sure about that question. Urena, you're welcome. Chrissy Boo Babe, you're welcome. So Nura, after they denied me, I sent in applications and have done so I apply again. Right. So as long as you qualify in other ways, then you should be fine. As long as you have the asylum application pending. If the I-130 and I-130A are approved, can I file for work permit before adjustment of status? The adjustment of status, the work permit has to go along with the adjustment of status application. So in the case, now, if you have the I-130 and I-130A approved, now if your spouse is a green card holder, then you know, it's not going to, you wouldn't be able to apply for a work permit, especially if you don't have your papers or any kind of, because you must, if you are married to a green card holder in the United States and you want to do adjustment of status, you must maintain your legal status in the United States throughout the entire process. So when it comes around to adjustment of status, you must have some sort of legal status, or you must be married to a U.S. citizen. If you're married to a U.S. citizen, then usually what happens is you would file the I-130, the I-130A, the adjustment of status, the work permit all together. And then they would issue the work permit a couple months, like 6 to 8 months after you apply. But if you don't fall within this category and you do not have your papers or any kind of status, then you would not be able to apply for the work permit. And you definitely wouldn't be able to apply for the work permit before the adjustment of status, because the work permit and the adjustment of status, they usually go together. So Chrissy Boo Boo Babe, still waiting. So are you waiting on me to answer your question? Let's see if you asked a question. Maybe I missed it. Or okay, so I saw your question about the taxes. I didn't see any other questions. But follow up, type your questions again if you have another question. Denny K24, you're welcome. Nura, do I have to apply again the work permit after biometrics? Thank you so much. You know, I don't want to tell you what to do because this is general information. In order to provide you accurate legal advice, that's where I would want to sit down with you in a consultation to tell you, advise you directly. But if I don't have any information about your application, your status, what you've what is in the application, when you applied or anything like that, it's hard for me to give you specific advice about whether you should apply after the biometrics appointment. What you can do is give me a call at 561-405-4889, and then we can you can get on my schedule, and then we can talk more about when you should apply for the work permit, especially after it was denied before. I don't want to provide you inaccurate information without being able to ask you detailed questions and accurately give you advice. User 543, how much time would take I-130 alien relative? So the I-130 is filed by both U.S. citizens and the green card holders. So it depends on the type of family member that you're applying for, and it also depends on the U.S. relatives' status, whether they're a U.S. citizen or a green card holder. So it all really depends. So Little Star Rush, let's see. Peter James, you're welcome. Nura, you're welcome. Let's see. So where you have a denial, so Fabulous Moy, where you have a denial, I would want to sit down and review that in detail, because that is that gets into complex a complex territory, and I would want to make sure that I provide you accurate information to tell you whether you should refile or file a motion, an appeal. So give me a call at 561-405-4889, and then we can talk more about what happened with that denial, and then and then come up with a plan for how to move forward. My husband sent in his N400. I already filed I-130. Do I wait to send in the I-485? So you have to wait until that I-130 is approved and an immigrant visa number becomes available. Right now, it is currently available. There is no wait list. So you can, since you have one pending, you will have to wait to submit that I-485 because your husband is not yet a U.S. citizen. So you wouldn't qualify as the spouse of a U.S. citizen yet. But when he does become a U.S. citizen, then you will need to notify the USCIS that he is now a U.S. citizen and that you are now the spouse of a U.S. citizen. And then you could submit that I-485 to show that you'll be adjusting status. And of course, that is conditioned on you qualifying in every other way for the adjustment of status. So Lil Star Rush, I'm not seeing your question for some reason. Let me see here. I am not seeing, I see you keep saying that you've resent the question, but I don't see it. I'm just going through to see if I spot it. So for some reason, it's not coming through. I don't know why. I think if you frequently lose connection, when you lose connection, your question disappears. So I don't know if you're losing connection from the live, and that is affecting the question coming through. But I don't see it. So I see one part of it up here, but I don't see the rest of it. So you can try one more time. Let's see if we see it again. Okay, so I think I see it now. How long does it normally take? Okay. So Peter James, yes, my website. If you go to the link in my bio, you will find my website. It's going to take you to the website, and you can find all the information about me and the firm on that website. It's www.stlawoffice.com. Hi there, Miguel. It's nice to see you. Good evening. Thank you so much for those of you who've shared my live. I see that you're sharing my live. So how long does it take? So I don't know if you're talking about the I-130, but it really depends on who submitted the I-130, which U.S. relative submitted the I-130, and your status. So it's if you can get more specific than that, then I can answer, give you a narrower answer. So Fabulous Moy. So the best time to call would be between 8:30 and 6:30 in the evening. So those are the best times to call to be able to get immediate assistance. You can always call if you want to. There will be a receptionist who answers the phone, but they're after hour receptionists, and they will not be able to schedule the consultation. What they'll do is take your information and then provide it to the firm's full-time receptionist in the morning, and then she can call you and talk to you in depth about how to schedule a consultation. So Fabulous Moy, just give us a call. You can give us a call now, but you will, you won't get immediate assistance. You could call in the morning, between 8:30 and 6:30. Kuntel 19, I'm already in the USA. Okay, so I think that's related to maybe something I answered before. Deandra, thank you for sharing my life. How long after biometrics do they send your work permit? So right now I'd say it's taking about 6 to 8 months. Queen Josette, thanks for following me. I really appreciate that. How long after biometrics to receive the work permit? That's Sassage. It's about 6 to 8 months. Could be less, could be more, but the average is 6 to 8 months right now. I have urgent case and I only have 1 week. So definitely give us a call tomorrow morning and get in on my calendar, and we will definitely treat it as an emergency. As long as you get on it and you contact me, and they will put you in for an emergency appointment. Miguel, thank you for the free consultation. I will call tomorrow. Yes, I am looking forward to hearing from you. So my family is waiting for interviews since September for the green card, but they haven't called. So it depends on what's going on in that case. It depends on what type of process you're going through. So, it's hard to give you an answer on that. Okay, I think I see more. Let me see. Okay, so my family is waiting for the interviews in September for the green card, but they haven't called. On a whole, we're seeing a lot of delays and backlogs. It was just in the news that over 380,000 immigrants are now in line waiting, and they're backlogged. So, of course, that is probably the reason why you haven't heard. But if you feel like you need further assistance, give me a call and we can definitely talk about it. And thanks, Miguel, for sharing my life. Sausage for Form I-765. So yes, it's taking 6 to 8 months for that work permit on the I-765. Keep in mind, it could be less, could be more. I've seen as little as 4 months. But I have seen as long as 8 months. So it is be prepared for the long haul, but you'll be lucky if you get it in less time. Thank you, you State One, for sharing my live. I really appreciate that. So I am going to close out tonight, but I want to thank you for all your great questions. Thank you for sharing. Thank you for following. If I miss your question, hang on to it and follow me. As soon as you see me go live, drop your questions and I will answer. No problem. I'll prioritize your questions. So we have some more. Let me see if I can get through this. Miguel, I'm looking forward to your call. Can they work in the U.S. while they wait for their green card? It depends. So it depends on what you qualify for. If you do qualify for a work permit and you get the work permit, then yes, but it depends on what your circumstances are. Miguel, they're getting their green card through my mother in Haiti. Yes, there have been delays and backlogs. So hopefully as the year moves forward, they will clear that backlog. But if you need help, just don't hesitate to call. Fabulous Moy, do you do free consultations and then I can work with you after? So no, I don't do free consultations. The consultation fee is $150. But you do walk away with, I do spend time with you, and that is why there is a cost, because I do spend up to an hour with each person that I speak with. I go through your circumstances in detail, and you walk out with a plan, or you walk out with me as your attorney. So either way, you walk out with value. So if you would like, just go ahead and call and get that scheduled. Denny K, can you provide a few reasons they may not grant the green card, even if your husband is a U.S. citizen? So usually if you are inadmissible, you have criminal issues. If you have crossed the border without your papers, which in this case, it sounds like there's a visa involved, so there's no worry there. So if there's misrepresentation, meaning that there is some omission or there's a lie on the application, these can stop. These are the most common reasons for denials. Other reasons is if you don't do the paperwork properly. For example, I've seen denials where the affidavit of support was done incorrectly. And even though it had nothing to do with the relationship or anything like that, it still led to a denial. So those could also, insufficient documents, insufficient evidence can also lead to a denial. Lil Star Rush, for some reason, your questions aren't coming across. They're choppy. But I am going to close out. But what you can do is hop on next time and just ask your question again. I thought your question was how long does I-130 take? But it may not be. So just hang on to your questions, and hopefully next time it will be better and I can see your answers. So LC Antigua, can they work here in the United States while they wait for the green card? I think I answered that, and it depends on whether they qualify for an immigration benefit and the work permit. What's the process to bring someone from another country already married? I am a U.S. citizen and he isn't. So if you are a U.S. citizen and he came in the country with a visa, and he came into the country, say with a visa and overstayed, and there are no other disqualifying factors, then your spouse could qualify for the adjustment of status process, which means that they apply for the green card while they're in the United States. So that is basically the process. If you would like a full evaluation of your case, you can give me a call at 561-405-4889, and we can go into detail with your particular circumstances to see. Now, if your spouse came across the border and he did not come with papers, then that's going to be, it doesn't disqualify him from getting the green card, but it definitely makes it a little more complicated. All right, so I am going to close out. Chrissy Boo, babe, thank you. I appreciate that. And thank you for your support. So I'm going to close out. Thanks so much for tuning in, and I will see you tomorrow. Hold on to your questions. Follow me. You'll see when I go live. Then you throw the questions in the comments. And little star rush. I'm sorry your question could never come across, but maybe next time we'll have better luck and I can answer your question. Have a good night, guys. Bye.